Since the ratification of the Magna Carta in 1215, the right of accused people to be tried by their peers has been an essential protection against government overreach in English common law. That function was so vital that denial of the right to trial by jury was one of the American Revolutionaries' core grievances that led them to declare independence from Great Britain in 1776. Fast forward to 2023, and the Scottish government will pilot trying certain serious sexual assault cases without a jury. This may be motivated by a sincere desire to get justice for victims. Still, undermining juries only consolidates the power of government ministers and senior judges. The rationale of the proposal is simple. Convictions for sexual assault are low, and the Scottish government believes that juries are partly responsible. Scotland's Justice Secretary, Angela Constance, has cited the prevalence of preconceptions among juries. This refers to the tendency of juries to believe common rape myths about the nature of consent and the relevance of victims' previous sexual behavior. Although we should absolutely tackle these pernicious myths, it is not the core reason for the low conviction rate. Poor policing, low reporting, and the inherent difficulty with gathering evidence to prove an accusation are far more significant obstacles. Even if the Scottish government's complaints were valid, it would not justify abolishing juries or diminishing their role. Trials conducted by an independent judiciary and resolved by juries are vital checks to state power. The government can investigate and charge people with crimes, take proportionate action to bring justice to victims, and protect society from violence. The judiciary's role is to safeguard people's rights in the process and ensure the state does not victimize innocent people. Trials are meant to evaluate the merits of individual cases. It would be profoundly unjust to subject people to fines, probation, imprisonment, and a life spent labeled as a sex offender just to satisfy the Scottish government's arbitrary prosecution quota. That simply perpetuates the cycle of victimization and relegates innocent people unfortunate enough to be accused of sex crimes to being collateral damage. On this issue in particular, the risk of collateral damage is significant. It is true that throughout history, women have been treated unequally, denied liberty, and treated as men's property. But we have seen how a vengeful, collectivist approach to sexual justice has tangibly damaged both men and women. The "believe all women" mentality instilled by the Me Too era saw some men accused of sexual misconduct with claims that were either false or exaggerated. A February 2020 survey found that 60% of men are now afraid to mentor women in the workplace for fear of malicious or false accusations. Translating this mindset, that blaming innocent men can be justified on the basis that women have been victimized as a collective in the past, into our formal justice system, where people's liberty and property are on the line, would be unconscionable. As Johnny Depp's lawsuit against Amber Heard showed, juries are vital to preventing the law from doing just that. Subscribe Libertarian Facts.